In just 1 week, ordinary people like you and me will walk into a Plymouth County, Massachusetts courtroom and possibly be impaneled for one of the most emotionally charged criminal cases that is finally heading to trial this year. In fact, it's happening in my county, so I will be following it very closely. And it's the Commonwealth versus Lindsay Clancy. Jurors will carry one of the heaviest responsibilities imaginable, deciding whether Lindsay Clancy was a cold, calculating monster or a mother whose mind had become compromised by overmedication and severe postpartum depression, that the law says she cannot be held criminally responsible for the terribly fatal injuries that she committed upon her 3 young children. Welcome back to Lunchtime Law on the Margaret McLean Show. I'm a former prosecutor, civil trial lawyer, and law professor. This is where we take the legal stories dominating the headlines and translate what is actually happening inside the investigations and, of course, inside the courtroom. Before we dive into the pretrial maneuvers, let's ground ourselves in the core facts of this case. On January 24th, 2023, emergency responders in the quiet coastal town of Duxbury, Massachusetts, were called to a home on Summer Street following a severe medical emergency. So Patrick Clancy had returned home to find his wife, Lindsay, critically injured after jumping from a second-story window. And tragically, inside that home, the couple's 3 young children, Cora Dawson and baby Callan, had suffered fatal injuries. Cora and Dawson passed away that evening, and infant Callan passed away days later. Now, Lindsay Clancy, who was a labor and delivery nurse at Mass General Hospital, survived the event but was left permanently paralyzed from the waist down. And now she faces 3 counts of first-degree M. The central question for the jury is not who was responsible for this tragedy, because Clancy admits to the horrific facts surrounding the fatal injuries that she committed with exercise bands, and you can only imagine, right? It's her mental state at the exact moment the attacks occurred that's the issue. So the state argues this was a calculated, intentional act, but the defense maintains it was the direct result of severe postpartum psychosis and a medical reaction to a revolving cocktail of heavy prescription medications. So that is the backdrop as we head into the courtroom next week. Occurring just days ago illustrates prosecutorial strategy. On July 9th, Plymouth Superior Court Judge William Sullivan granted the state's motion to drop 3 secondary counts regarding the physical mechanics of the offenses, so the 3 strangulation counts. Now, a layperson looks at that headline and wonders, is the state's case falling apart? As a former prosecutor, I can tell you the answer is a definitive no. This is a classic move to tighten the focus of the prosecution. So when an indictment is cluttered with duplicative, overlapping offenses, you sometimes invite jury confusion. You give a hesitant jury a backdoor, a way to duck a first-degree M conviction by compromising on a lesser charge. So, by stripping away those counts, the Commonwealth forces the jury into a clear binary choice. So they can choose the core counts, right, of M, or a finding of lack of criminal responsibility. It's clean, aggressive trial advocacy. The state also secured victories on the evidentiary front. Judge Sullivan ruled that the jury will hear the full, agonizing 911 call made by Patrick Clancy. They will also be permitted to view the state's official medical and forensics photographs. Now, in my law classes, the students and I analyzed Massachusetts Rule of Evidence 403 a lot. It dictates that a judge must exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice. Now, defense attorney Kevin Reddington fought against these forensic visuals, calling them unnecessarily graphic. But the court followed standard homicide jurisprudence. The state has the burden to prove the element of intent and the exact nature of the offenses. So the photographs are highly probative of those elements. Now, it's interesting because recognizing this procedural loss, Kevin Reddington is making an extraordinarily tactical pivot. He has indicated that he may request that Lindsay Clancy, who is paralyzed and uses a wheelchair, be excused from the courtroom when those medical photos are displayed. Now, why is that? Because as a defense attorney, you cannot win if the jury spends 10 minutes watching your client react indifferently to the state's primary evidence. It's entirely about controlling the optics and managing emotional impact in the room. Let's pull back the curtain on how this trial will actually begin next week. You cannot try a case this emotionally volatile with a standard jury selection process. The defense has already requested an expanded panel of 18 jurors and asked for additional challenges to dismiss prospective jurors without cause. So, furthermore, the court is heavily considering using a highly specialized written jury questionnaire. So, in a standard verbal voir dire, when a judge asks a room of like 80 people, does anybody have a bias against a psychiatric defense? I'm telling you, almost no one raises their hand. I mean, people don't like to admit bias or personal struggles in a public room full of strangers. But when you hand somebody a written questionnaire in a quiet room, the truth is likely to come out. Some people find it far easier to write down their family's experiences with severe postpartum depression or other mental illness, or their deeply held beliefs about accountability when you hand them a written questionnaire, right? So, if I'm the prosecutor picking this jury, I'm looking for analytical, rule following individuals. I'm thinking, accountants, data analysts, or engineers. I want jurors who can compartmentalize their immense natural sympathy for a grieving family and focus strictly on the timeline, the actions, and the objective facts and the evidence of January 24th, 2023. If I'm the defense, I'm looking for the exact opposite. I want jurors with high emotional intelligence. I'd say educators, parents, or individuals who have personally navigated the complex, sometimes terrifying world of medical treatment and prescription medication. I need jurors who can look past the horrific results and ask the fundamental question: what was Lindsay Clancy's mental reality? And the defense is running a lack of criminal responsibility defense, which is the modern statutory framework for the insanity defense. Many people mistakenly believe that the defense bears the burden of proving a mental defect at trial. But in Massachusetts, the law features a unique, powerful shift in the burden of proof. And before we get into that, which I'll break down tomorrow on Lunchtime Law, I'd like to show you a clip of my interview with attorney Tommy Pope. Now, he prosecuted Susan Smith back in the 1995, I believe, for taking the lives of her two children. It was a horrible case involving a drowning in a lake where she backed the car down. I mentioned to him that when I polled some of my friends about this case, I talked to them about the facts. I said, what would you do? Most of them were mothers around my age. Um, most of them said that they couldn't convict Lindsay Clancy because of the amount of prescribed medication that she was on and for the postpartum depression that she suffered. So it will be very interesting to see what happens here. On the other hand, in the minority of my friends, they said they still felt that the prosecution so far has produced enough evidence of premeditation and planning. So let's see what Tommy Pope has to say. I think it's kind of interesting. And then in the comments, tell me what you think of the case so far. So here's my clip with Tommy Pope.
About
hmm
um, your friends talking about, they didn't think they would convict. And it kind of reminds me back at Smith, um, you know, some people said, I battled depression, or I went through this, or I went through that, or I was on Prozac, or whatever the case may be, but I still wouldn't kill my child. And I think
No.
that's the biggest thing so there's pros and cons. There's mothers. I mean, you could even go as far as, and that's why the prosecution's got to be careful. You could go as far as mothers who have had postpartum depression, and I think they could appreciate it, but still recognize I never would kill my child. I might have thought, I wish I didn't have children, but I would have not taken their life.
That's all I have today for Lunchtime Law. I will be playing you more of that clip throughout the week as I discuss this case in more detail. But in the meantime, please subscribe and thank you so much for following the Margaret McLean Show. And I appreciate all of your comments. I'll see you tomorrow.